Okay, let's start this session on what kind of political project does the European Union have or should have for its future. I'm very happy to see that many of you have joined us again for this afternoon session. We are still awaiting one or two of the panelists who should join us shortly, I hope. If I may ask, Olivier de Schutter has just arrived. Hello, Olivier. Thanks to have you with us. It's very good to see you online. If I may ask everyone to switch off their microphones, also of the panelists and the speakers, until such time as you take the floor, to avoid noises in the background. Everyone participating in the audience, and we have over 1,300 registrations for this conference, is invited to ask and to pose their questions through the Q&A that you see appearing on the right hand of your screen. And the questions will then be assembled and put to our panelists and discussants by Karen Kohn, who's also appearing on your screen here, from the European Law Journal, because this conference is a co-organization by the College of Europe and the European Law Journal. And just so that you know, the discussions that we will have today will also inspire a further reflection that will be then presented in the papers that will later on be published in a special issue also of the European Law Journal. Now, without further ado, let me start this session. It's a very special session, of course. We start with what kind of political project before looking at the format that the institutions and decision-making should take for the future. Let me remind you that this morning already we said that the exercise that we have today and tomorrow is all about establishing what the strengths are of the current system that should be maintained and pinpointing the flaws, remedies for the future. This first session this afternoon deals with very important topics. Of course, the whole conference deals with very important topics. Let's be sure about that. But this morning already, we have heard the word democracy, I think more than any other word, pronounced by the President of the European Parliament, David Sassoli. So it is only natural also, we felt that in the current context, we need to have a first reflection on upholding EU values, democracy, rule of law and fundamental rights, followed by another very important challenge that the European Union, but also the world is facing today, which is how to deal with digitalization, so the digital Europe. And then a third very important topic, also migration and asylum, because of course, when we talk about democracy, fundamental rights and access to the digital, that is not only reserved to our citizens of the European Union, but it is something to be reserved to all humans, regardless of nationality. So we have bundled those three topics in our first session. It is also topics that have been very much at the forefront of the activities of the Law Department of the College of Europe. Our recent conferences, which have emanated in books, are precisely on constitutional democracy in the European Union. We're on the internal market 2.0, and we're also on democracy in the digital age. So today is a continuation of efforts done to improve, thank you, Andrea, to show the book, to improve the European integration process. It is not a final point, it is a point in passing, but we hope it will be a decisive point to steer the reflections in one or the other direction. And to do that, we have with us experts in their fields. Of course, they do not need introduction, but let me briefly point out their names and faces, because I'm sure you've all read our panelists, but you may not have seen or interacted with our panelists up till now. We have, to talk about democracy, rule of law and fundamental rights, Olivier de Schutter. Thank you very much for having joined us, Olivier, who is a professor at the UCL and who is a UN Special Rapporteur in various fields, I would say, by now. And he's also visiting professor at College of Europe, Natolin. Olivier, you have the floor. If I may ask you to talk for about 10 minutes to induce further discussion and reflection afterwards.
Thank you very much, Inge, for having me at this important conference. And I very much welcome the opportunity to have a dialogue on this most fundamental issue, which is how can the EU better protect the values listed in Article 2 of the EU Treaty that states joining the EU have pledged to adhere to. Now, I have 10 minutes, and in these 10 minutes, I'll try to convince you that we have not yet used the full range of tools that could be used in order to ensure that states remain in line with those values that I've cited, democracy, human rights, the rule of law. The debate on EU values, of course, usually centers around Article 7 of the EU Treaty that provides a form of political monitoring, ultimately in the hands of the European Council since the Treaty of Amsterdam. And that has been used, or that we have tried to use in the context of the regression of the rule of law in Poland and in Hungary. Now, the failure to effectively use this tool is usually attributed to the fact that we need a unanimous European Council in order to impose sanctions in the presence of a serious and persistent breach of the values listed in Article 2. But I would like to highlight that there are maybe two other reasons why this is has been a problematic route to use. The first reason is that Article 7 of the treaty has not been fully used, and indeed, I would argue, even understood by the institutional actors, despite the opportunities it presents. Let me recall that Article 7 of the EU Treaty provides not for two possibilities: one, preventative approach where there's a serious, where there is a clear risk of a serious breach by a member state of the values listed in Article 2, and one remedial approach in the presence of a serious and persistent breach. There is also the possibility under Article 7, paragraph 1, for the Council of the EU to decide by 4/5 of its members, in other terms, 21 member states, to address recommendations to a member state, even prior to any finding that there is a clear risk of a serious breach by that state of the EU values. And that 4/5 majority, with the consent of the European Parliament acting by a 2/3 majority of the votes cast, can be found in situations such as those raised by Hungary or Poland. So I believe that we have been not using this possibility for the Council of the EU to address recommendations to a state without any prior finding of there being a clear risk of a serious breach, simply if some worries emerge. And that would be based on a reasoned proposal by 9 states, 1/3 of the member states, by the European Parliament or by the European Commission. That's the first reason why Article 7 has not been, delivering on its promises. And the second reason is that each institution has designed its own toolbox in order to play its role under Article 7. The Council has developed these rule of law dialogues. The Parliament has adopted the practice of systematic annual resolutions on the situation of human rights in the EU. And the Commission, of course, has developed in 2014 its rule of law framework, and now the rule of law review cycle inaugurated in 2019 with the first annual rule of law report presented in September of last year. But these institutions have not been working collaboratively together, and especially have not been using the same consolidated review of the situation of human rights, democracy, and the rule of law in the member states that would allow them to show that their assessment is objective, impartial, not guided by political considerations, and informed by the findings from the UN, from the Council of Europe monitoring bodies. And in reports I presented to the European Parliament, I suggest that the Fundamental Rights Agency could be tasked with providing such an annual report on the basis of which the EU institutions could act in a way that is much more perhaps credible and does not raise the suspicion of it being politicized. So Article 7 is the first route, the first of the 4 tools I would like to describe. The second tool is judicial monitoring by the Court of Justice of the EU. I cannot enter into the details of this. We have, of course, the possibility of referral procedures from domestic courts. We have the possibility of national courts refusing to cooperate, for example, in the execution of the European arrest warrant, if the state that has emitted the warrant is not to be trusted with respect to fundamental rights or the rule of law. We have, thirdly, infringement proceedings that the Commission may file against states that violate fundamental rights in the scope of application of EU law. And we should remember that this is, for example, what the Commission did after, in 2017, Hungary adopted its law on higher education concerning, in fact, the Central European University in Budapest, and the judgment of the European Court of Justice of 6th of October 2020, with some help from WTO law, allowed to find Hungary in violation of its obligations. Now, infringement proceedings filed by the Commission in its role as guardian of the treaties under Article 258 of the Treaty on the Functioning of the EU are extremely interesting for a number of reasons. First, because not all violations of fundamental rights reach the level that is targeted by Article 7. The nuclear option of Article 7 is not always the plausible one for more minor violations. Secondly, because it allows to operate preventatively. The Commission may file infringement proceedings against the state, even if there have not been implementation measures yet. But for example, there's a draft law pending, right? Or there is a law adopted that has not yet been applied to individuals or companies. So it allows to act much more speedily and ex ante rather than ex post. And thirdly, it does not depend on individual litigants filing claims before domestic courts as prejudicial proceedings. And finally, it does not depend on political support of member states or indeed on the cooperation of domestic courts. So I think infringement proceedings are one perhaps underexplored route to protect the rule of law in the EU. And then finally, let me note that just a few weeks ago, the Dutch Parliament, the lower house of the Dutch Parliament, requested that the Dutch government sue Poland before the Court of Justice for disrespecting the rule of law. The Dutch government should report to the Dutch Parliament at the end of this month, by the 1st of February, about whether it shall file such proceedings. Of course, the Commission has to be given a chance to itself file infringement proceedings, but so interstate infringement proceedings might be another underexplored route to protect the rule of law. Now, the third tool is the power of the purse. In 2018, the Commission proposed a regulation that would allow the suspension of the delivery of funds from structural funds if it is found that there are, and I quote, generalized deficiencies as regards the rule of law in the recipient state. Now, as we know, this led to a major debate in the EU because Hungary and Poland particularly opposed this idea. And at its meeting of 10th and 11th of December 2020, the European Council found a compromise on this draft regulation, now renamed Regulation on the General Regime of Conditionality for the Protection of the EU Budget. Now, we are all familiar with the compromise that was reached, and I would like to make 3 comments on this compromise. First, it is regrettable that the regulation was made part of a package including the multi-annual financial framework and the Next Generation EU Recovery Plan, because this allowed Hungary and Poland to essentially blackmail the rest of the EU. If the German presidency had simply put the draft regulation to vote, right, and this would have been a qualified majority vote, Hungary, Poland would have been isolated. And it would not have been possible for these countries to take Europe hostage in this package deal that was sought. In addition, as we know, part of the compromise is to allow the application of the regulation to be delayed, to give time to the Court of Justice to examine any action for annulment, and for the Commission to adopt guidelines on how it shall then implement the judgment delivered by the Court of Justice. In total, it's at least 2 years before that regulation can be applied. And we'll have general elections in Poland and Hungary, respectively, in 2022, 2023. The rule of law may be irremediably damaged by the time the regulation is actually implementable as a result of this compromise. The only good thing about this compromise, however, is that it will give the Commission an opportunity to strengthen its role in supervising compliance with the rule of law in the EU beyond the current practice of the annual review cycle of the rule of law in the EU. And the Commission shall have to develop tools that will allow it to objectively, impartially assess compliance with the rule of law across the EU member states, and that may be one benefit of the compromise. And then there is finally a fourth tool that is not usually thought about, but that it seems to me may be interesting to explore in the future. And that is the European semester. We have a growing number of country-specific recommendations adopted under the European semester that refer to the rule of law. For example, for Hungary 2019-2020, the CSRs, the country-specific recommendations, included reinforcing the anti-corruption framework and strengthening judicial independence. For Hungary 2020-2021, there was a CSR on ensuring that any emergency measures be strictly proportionate, limited in time, in line with European and international standards, and should not interfere with business activities and the stability of regulatory environments. For Poland, the CSR 2020-2021 was, inter alia, to enhance the investment climate, in particular by safeguarding judicial independence. Now, these country-specific recommendations adopted under the European semester by a qualified majority voting within the Council, although of course they seek a consensus, but based recommendations of the Commission that must be accepted by the Member States unless the Council explains why it does not follow these recommendations. These CSRs will be increasingly important because the next generation EU funding will depend on whether countries comply with the CSRs. And under the Recovery and Resilience Facility in particular, the national recovery and resilience plans shall be assessed on the basis, inter alia, of the question whether the member state submitting the plan is implementing the CSRs addressed to that state. And so I believe that this fourth tool, the European semester tool, may be one underexplored tool we have in our toolbox in order to address the major threats to the rule of law we are now experiencing in some countries of the EU. And I would like to thank you again for providing me an opportunity to discuss these issues with you. I look forward to our discussion. Thank you.
Thank you very much, Olivier de Schutter. I saw that you focused especially on the tools to ensure the enforcement by member states of the rule of law. And what I appreciated also very much is that you look not only at the reactive tools, but also at the ex ante, the preventative tools, which indeed are probably even more important, because when you have to react, it's already too late in a certain sense. So I'm sure there's going to be a lot of comments and questions in relation to that. I would like to now pass to the other main topic of the current contextual setting, which is the digitalization with Andrea Renda. Andrea, you also have 10 minutes to talk to us about also this very difficult and complex issue. If I may remind all of you that Andrea Renda is a Senior Research Fellow and Head of Global Governance, Regulation, Innovation and the Digital Economy at CEPS, and he's also a visiting professor at the Law Department here in Bruges. Andrea, you have the floor.
Thank you very much, Inge. was deeply interested by Olivier's presentation and eager to. I mean, my temptation would be to continue that discussion rather than move to the digital one. But I will bring you a little bit for 10 minutes into the digital one, which is structured and approached in a completely different way. Meaning that what I've tried to do is to sort of project Europe as a project. A little bit further down the road in a sort of medium term, and see what kind of trends in the way in which we approach lawmaking, but also in the way in which we structure the European cyber policy. I mean, what are the trends that could be identified there, and what are the key instruments and tools that could be used at the European level to really make the most out of the digital transformation. I want to share the screen and bring you into my presentation. Here, I have some slides that I'm showing. That is the most meaningful one, winning the total, obviously. Meaning, when the internet started 3 decades ago, more or less, as World Wide Web populating and permeating our lives, most computer scientists were describing it as a layered environment, right? Where there was a physical layer, there was an open logical layer made of open standards. There was a possibility of running applications without asking anyone's permissions. And this is why people started using the expression permissionless innovation. And content could run on those applications and then reach out to the end users, who were completely free to exchange information with no filtering between the different end users. So that's why we call it an end-to-end architecture, an open architecture. And that architecture was thought to be revolutionary, highly innovative, very, very democratic, because it would be treating all users alike. And at the same time, the decision was made to leave that architecture largely unregulated, right? Everywhere around the world, or almost everywhere around the world, the internet has largely been left shielded from sectoral regulation, or even in many cases cross-cutting regulation. And even when there has been an attempt to use the law to constrain the internet and the behavior of users on the internet, in most cases, these attempts have failed. Think about copyright enforcement on the internet, which is still largely a failed attempt, in many respects. Think about privacy protection in many respects, although I'm sure I can discuss that with Paul later on. And think about hate speech and many of the things that we're seeing today. In particular, in the first evolution of the internet, what we have seen is that this overabundance of information that was being created gradually created a poverty of attention. And those players that have monetized the attention gradually acquired a very prominent position on the internet. It's the so-called platforms that today leads to some dynamics on the internet that sort of derogate from the original idea of the fully open internet and start ushering into an era of managed, controlled information, customized services, mass customization, and many, many other aspects. Now, faced with this development, it is now, I think, well settled that the internet as we know it today has been generating a number of problems in terms of economic, social, and even environmental unsustainability. Most importantly, the fact that the internet is a gigantic machine that personalizes information for each of the end users has gradually created what we call filter bubbles or echo chambers on the internet, distancing citizens from reality, meaning that each of us sees a versioned, customized representation of reality, which is not necessarily corresponding to the underlying reality, but it's how the surrounding information envelope that the internet represents for all of us is shaping our perception of reality. Some recent examples of how this trend is becoming extremely fast and extremely difficult to control are last year's documentary, in which we saw a mother celebrating in virtual reality the 7th birthday of her daughter, despite the fact that her daughter had passed away 3 years before. Just to give you a sense of what deepfakes and generative adversarial network techniques in artificial intelligence are able to do today. And for those of you that watched the documentary, you could see the extreme confusion between what is real and what is not real, and projects in the medium term a human being surrounded by an information environment in which it's very difficult to place any form of trust. Similarly, the use of deepfakes really give us a sense of the inability to distinguish what is a representation of reality from reality. Similarly, what is sometimes presented as completely automated and the result of, for example, new artificial intelligence techniques, such as the checkout-free stores, sometimes hide completely different realities. These workers in Madagascar are manually correcting what artificial intelligence gets wrong in Amazon's checkout-free stores. And this is also more ironic because not only it is a different type of distance between reality and its representation, the one that we consume on a daily basis, but it's also an idea of gives us an idea of what is the impact of the internet and the platformization of the internet on labor markets, creating hidden forms of labor, and even labor that is largely about training a machine that one day will replace you. And obviously, we've seen also uncontrolled flows of information that are then used by governments to profile people and thereby violate fundamental rights. So basically, what we see is what Magritte would have represented as the distance between reality and its representation. This is not a pipe, this is its representation, and this is why this work is appropriate when it comes to the internet. Now, my first question, as I'm roughly halfway through my presentation, and then I'll rush through a few other slides, is can an internet that has proven to be unsustainable and deeply unsustainable until now be presented by the European Commission today as the digital transformation that is part of the twin transition? So the really the growth and prosperity project for Europe, together with obviously with the green transition. Well, my impression is that the answer is that when we think about the future of cyber policy at EU level, the role of government will actually have to be much stronger, and the control over the internet that has been absent for the first 3 decades, or let's say the first 2 decades, because then there has been a bouncing back, but the control that has been largely absent, we have to become much stronger. And then I will try to answer a little bit how in the remaining few minutes. So indeed, if you look at the mandates of Margrethe Vestager, the Vice President of the European Commission, that has a mandate of making Europe fit for the digital age, in my opinion, is not entirely correct as we see it today. It's actually the other way around. It is much more important that in the coming years, while modernizing its approach, Europe is entirely focusing on making the digital age fit for its values and its principles. And that is going to be very complicated because, as Inge was saying before, doing things exposed is very difficult. So jumping on a runaway train after 3 decades, it's going to be very complicated. So if you bear with me a few more minutes, I will bring you through what I think are the key principles in lawmaking that will have to dictate the changing attitude of Europe towards cyberspace, and then show you how I portray the layered architecture of the internet compared to the one that I showed you at the beginning of this presentation. So first thing, and I go very quickly through this, happy to elaborate on each of those, is increased use of foresight in policymaking. We cannot regulate what we see today, because by the time rules will be in place, the subject matter will be different. First attempt is the European Commission's data strategy that is based on the idea that while we store 80% of our data today in the cloud, in 5 years from now, we'll be storing most of our data, 80% of our data, in the devices or at the edge, so in a more decentralized architecture. The second principle is principles-based regulation. First attempts include the specification of principles of trustworthy AI, and Adventure have been part of the high-level expert group on artificial intelligence, and the attempt to operationalize these principles into requirements, 7 requirements that will then be part of the forthcoming AI regulation that will be out, the proposal of the European Commission, out on the 27th of March this year. The third principle is outcome-based regulation. Innovation and digital transformation needs direction. And fundamental rights, as Olivier was mentioning before, and more generally, in my opinion, the Sustainable Development Goals should be the North Star of any legislation that wants to use technology as a means to reach a vision of society in the medium term. There is no way and no use in technology as an end, and we very often make that mistake. Risk-based regulation is going to be very complicated because it cannot rely on ex-ante risk classifications anymore. You will see that this is a problem with the forthcoming AI regulation because risk evolves over time, constantly. We need to find ways to engage in risk-based regulation that is proportionate, dynamic, and agile. We need agile governance, meaning that we need something that is more dynamic and flexible than only courts, and perhaps more able to change in real time the standards and provide more legal certainty. And as I will say in a second, this is largely a combination of, let's say, expert bodies, but also technological and technical specifications, which is a key challenge for the law. And finally, we probably need shared values at the international level because the extraterritoriality of our rules is easily defeated by the plasticity of the internet. So currently we see, but I don't dwell on this, really, particularly in artificial intelligence, really different trends in between building a global partnership or actually forking entirely and splitting the protocols and specifications of the internet in 2 or 3 different parts, depending on the big superpower that manages them, which is one key important scenario that the EU should try to avoid. Now, last slide to reassure Inge, though it's a bit of a difficult one, but I go through this quickly. What does this mean for the layered architecture that I showed you at the beginning? What I see happening increasingly at the EU level, and this is more the work that I've done as part of the Internal Market 2.0 conference. So after that conference that Inge and Sasha have been organizing now several months ago, we will see new forms of connectivity coming in, and the European Union has to be very good at getting the technology mix right. We are going into what I call a Lessig moment in the paper, the draft paper that I have prepared, meaning the idea that you can embed compliance with legal rules, at least partly, in technological specifications and protocols. And this is the attempt of the federated cloud environment with Gaia X. We will have increasingly to deal with a denser and denser Internet of Things with billions and billions of devices, an estimated 1 trillion devices connected to the internet in 2035. You can only imagine what kind of information flows this will generate in the future. We will actually have to fuel the internet with more layers of verification and authentication to ensure that what was once a very anarchic environment has to becomes, at least partly for the key services and the critical parts, a much more controlled environment inevitably. And then we will have the data spaces. We will have to, if you wish, backtrack a little bit from the idea that all data are openly flowing on the internet and bring managed data environments where users, businesses, and other players on the internet can keep control of the data flows. The European Commission has proposed a number of data spaces. I don't dwell on this in the presentation to save time, but you will have that the top layer of the internet will be increasingly made of 4 different provinces, if you wish. Sectoral data spaces with managed data flows, the original open internet with the additional distributed ledger technologies, digital platforms, so the first evolution of the internet that we see today, and the space for digital government, which is increasingly important. Now, obviously, end users will have to be involved, hopefully in a meaningful way. In the paper, I provide a couple of comments in that respect, and we will have 2 horizontal, very important developments that will be among the key challenges of the coming years. One is how to incorporate artificial intelligence in all these layers. And the second one will be how to ensure that we move towards enhanced user control over data flows. Now, just to give you a visual sense of how much more complicated, complex, dense, layered, and managed, if you wish, I see the internet of the future from a European perspective. And I do believe that this is perhaps the only way in which the EU will manage to tame the beast of the digital transformation and maybe ensure that the digital environment serves the purposes and the vision that the European Union has given itself for the medium term. I'll stop there. I'm happy to elaborate on each of those aspects. Thank you very much. Back to Inge.
Thank you very much, Andrea, for this very exciting, I would say, presentation. In particular, I liked your first slide, which was the black one, I think it was most easy to comprehend. You have clearly identified the challenge, which is the impact of digitalization also on democracy and society. And of course, the thing is to turn this into an opportunity. And you said we have to make sure that the digital age is fit for Europe, but we understand also that this is not an easy thing to do. I'm also convinced that there will be a lot of questions and comments on this, on how to change this challenge into an opportunity for Europe in a globalized world. Let's not forget we have that context also to reckon with. Let's first go to the third topic of today, the third challenge, which needs to be turned into an opportunity, which is migration and asylum. And to do that, we have with us Professor Elsbeth Guild. Elsbeth Guild is also visiting professor at the College of Europe in the Law Department, but she's a professor at Queen Mary University of London, as well as at Radboud University Nijmegen, and her specialization, as everyone knows, is of course migration and asylum. Elsbeth, you have the floor.
Thank you so much, Inge, and thank you for this opportunity and the challenge to fit into 10 to 15 minutes a presentation about an issue which has been horrifically complicated for the EU. So I'm going to start off with what do we mean when we talk about migration? And we need to be very careful about the words migration and migrant. They tend to be traps into which we fall because there's no international definition of either of them. And the way in which we speak about migration and migrants tends to be pushed by a particular agenda where those who are using the terms and for their political supporters are never the objects of it. So the fact that we are citizens of one country, when we cross an international border, we become a migrant under the International Organization for Migration's definition, is never the possibility for those who want to use migrant as a proxy for expressing certain kinds of prejudice. The second problem we have is defining asylum. Now that's quite clear because we have a refugee convention, we have a convention against torture. The EU has incorporated the standards of who needs international protection. And yet there's a tendency not to talk about refugees, but to talk about asylum seekers as if they are somehow part of a problem. One of the reasons in Europe that we have so much difficulty with migration and asylum is because we have found it extremely difficult to escape from a theoretical framework which was set back in the 19th century by Ernest Ravenstein of push and pull theory. There are reasons why people get pushed out of their country and there are reasons why people get pulled to another country. In the written version of this paper, I use the example of the Eurostat statistics on issue of first residence permits. And the 8th, 9th, and 10th largest countries of origin of people, third country nationals who get first residence permits in the EU are Turkey, Russia, and the United States of America. We would all probably think that, well, we can understand push-pull theory for Turkish nationals, maybe for Russians, but if you try and apply it to US nationals, that means they're being pushed out of the US by the lack of opportunity and pulled to the EU by greater opportunities. And that goes contrary to all of our received dogma about migration and about push-pull theory. So we need to think very carefully about using that theory. In the context of refugees, it's slightly greater because they're pushed by persecution in their country of origin. But in terms of migrants, we have to be very careful. And the other big problem with using push-pull theory in the context of migration is that it presupposes a kind of rational choice theory where the observer suggests this is rational for a person to move or this is not rational for a person to move. And we have a very senior dissident figure, Russian figure, who was almost killed in a poisoning accident in Siberia, who was treated in Germany, making a choice to go back to Russia to continue his campaign. Anyone looking at migration from push-pull theory would have said that was not possible. So we really need to rethink rational choice theory as how it works in this area. If we come to the current situation, I just want to remind us all that EU citizens have a right of free movement, nationals of 27 member states. There is a doctrine, highly expressed both in the treaties and promoted by the Commission, that internal movement is good. People should use their free movement rights. We pay students in Erasmus to move. We think movement is a very good idea. 3% of the population of the European Union lives in a member state other than that of his or her underlying nationality. Now that confounds two aspects of push-pull theory. First, not all parts of Europe have the same standard of living, the same wages, the same social benefits as others. In the absence of any restrictions on movement, why does nobody move? Therefore, what does push-pull theory do for us? Well, certain parts of Europe should now be utterly empty, i.e. southern Italy, and other parts should be really quite full, which they're not. The second is the idea that somehow restrictive laws and measures work as a way of regulating migration. And this is important because if we look at the world internationally, according to the International Organization for Migration, 3.9% of the world's population are migrants, whereas in the EU, it's only 3%. So with a whole lot of coercive laws and rules, we have more movement across international borders, and without them, we have less. So we need to rethink the value of regulation in general in this field. The second point, and now I'm going to leave my EU nationals, I'm going to go on to the Schengen border. When we established the Schengen area of free movement without controls on the movement of goods, persons, services, and capital, we did so by removing, in the context of people, an institution, and that institution was border guards. Instead of regulating what the legal status of people would be when they moved from one Schengen country to another, we abolished the institution. Now, that was extremely successful in completing the internal market. Tremendous benefits have accrued from that, and it was a very wise choice. But it confounded the view of a number of interior ministries that border controls somehow protect your country. And the group which would be instrumentalized in that perspective were asylum seekers. And the argument was, if you don't have border controls for asylum seekers, they will go asylum shopping, is the word that was used at the time. Now we're talking about self-relocation, and apply for asylum in a variety of different member states. That argument has been used as the tail of a dog, which is now wagging the internal market with the reintroduction of border controls. The 2015 hit of more than anticipated a couple of million asylum seekers and refugees from Syria primarily coming into the EU, an area of over 450 million people, was seen as some kind of huge problem. In fact, it was a problem about reception conditions. Some member states were just not willing to provide reception conditions. If we move to the next issue of our current situation, third country nationals, at least in EU law, we don't talk about migrants, we talk about third country nationals, which recognizes that they are citizens of some country, and another country has a political interest in ensuring that its citizens are well treated in the EU, as the EU has an interest to ensure that EU citizens are well treated in other countries. There is a reciprocity here, which is not evident and which is completely opaque when we use the word migrant and migrants. It's as if they don't have countries to which they are responsible. In the EU acquis, from the arrival of the competence in 1999 to third country nationals, we have huge fragmentation. We have directives on this and regulations on that, and tiny little bits like seasonal workers having their own directive. It's an utterly fragmented area of law. Very little coherence, and not even coherence in the terminology used among the different directives of fragmentation. Public policy is, of course, the classic one. The Court of Justice has accepted that it is a very it has different meanings in different directives, which does not help in any kind of coherence. Only 4.4% of the EU population are third country nationals. So we're speaking about a very small part of the EU. Refusal rates for visas is about 9%. Refusal rates on entry is about 0.005% of people who enter the EU. So we have a huge discourse about the problem of third country nationals. But according to Frontex, we only forcibly expelled 71,000 people last year. So there are very few people we actually want to get rid of. And we need to keep this in mind. Our fourth area is refugees. And between arriving at an external border and being recognized as a refugee, these people are called asylum seekers. Once again, the numbers in the third quarter of 2020, it was 11,000 people who applied for asylum in the EU. This, in an area of 450 million people, is not a huge number. Positive decisions are at 38%. They were about 45% a couple of years ago. They're down a bit, but that's first decisions. And we had a very big decision in Germany about Afghans, which meant over 3,000 people were given protection. That was just a couple of months ago. So appeals changed that perspective. The big problem in the EU of refugees is the articulation of the common European asylum system, and in particular, this whole idea of relocation. And this goes back to the creation of Schengen, the abolition of border controls, and an attempt somehow considered to be incredibly important in some interior ministries to control where this small number of people actually apply for asylum. And I'll come back to that in due course. Fifthly, we have search and rescue at sea. And here we have the problem which has come very much before the EU institutions, the Commission, the European Parliament. What is Frontex doing to prevent people dying in the Mediterranean? And there we have a series of intersections of international law. We have international law of the sea. It doesn't matter what a person's nationality is. There is an international obligation to ensure that they do not drown in any sea anywhere in the world. And there's a very complex and sophisticated system to ensure that. But we have the problem that the EU has, or at least some member states, have worked themselves into a frenzy that they are not going to engage or allow search and rescue in the Mediterranean if that means that these people will be disembarked on their territory. And that argument is then run on the basis that they're either asylum seekers or migrants, the whole mixed flow idea. Very unusual because, as we know, asylum seekers are a tiny, tiny proportion of people who enter the EU. And a number of our member states have gone from state-organized search and rescue in the Mediterranean to no search and rescue in the Mediterranean by state authorities, to outsourcing search and rescue to dubious third parties like the Libyan Coast Guard, which is unable and unwilling to protect migrants or asylum seekers, criminalizing NGOs, which sought to step into the space left on search and rescue, and prohibitions on disembarkation. And this whole agenda is run on the basis that there must be some kind of burden sharing. The idea that migrants or refugees are a burden is in itself very problematic because the European Union is selling in the MENA region that refugees are a benefit and an opportunity. So we're speaking through two different perspectives, but we've got ourselves into a position of stasis where people are dying in the Mediterranean, and the international community is increasingly engaging in lecturing the EU on how to prevent death at sea. We have the pact, the new pact on immigration and asylum, which the Commission produced in September, October. It was the subject of a tremendous amount of discussion and critique. And unfortunately, it does not resolve any of these issues. It does not present a viable alternative in any way to either the problem of protection of refugees, the prevention of drowning in the Mediterranean, or the consolidation of a proper EU acquis on third country nationals. We have, in the discourse of the EU, the problem of talking about perceptions. What are people's perceptions about migrants? Instead of talking about perceptions, perhaps we have to be more serious about ensuring that knowledge is properly shared, that perceptions are not being formulated on the basis of misinformation, which is perpetrated by those who may have political agendas on push-pull theory and how they are never migrants, which are unhelpful. We need to escape the trap of push-pull theory. The worst example of this was one that I heard in one member state, where a public official said that providing search and rescue at sea to little boats was a pull factor, and therefore the state should not engage in saving people at sea, notwithstanding the international obligations under the law of the sea. We need to have coherent policies with our neighbours and not seek to offload our responsibilities onto them. We have institutional trouble in that the embeddedness of interior ministries in some parts of the EU institutions is having a disproportionate weight in comparison with foreign ministries. We need also to think about how we better implement the role of fundamental rights in our policies. We need to consider how our civil society also needs to be taken into account. We need to think also of the role of judges and who's going to privilege fundamental rights and rule of law. So I think at that point, I would say my final comment is this field needs to be reappropriated from the far right, and perceptions must be realigned in the context of the realities of migration and asylum. Thank you very much for your attention.
Thank you very much, Elsbeth. You have thrown in a lot of thought for reflection in a very short time. Thank you very much for that. It's a crucial issue, of course, and you have shown very clearly that words and concepts and theories matter and should be critically assessed, not just be reproduced as such. And in particular, also the terminology third country national indeed is something that perhaps we may want to take on board in the framework of this conference systematically. And I would also like to, as you did, also to remind us that human rights belong to humans regardless of nationality, and should therefore also be a factor which the European Union should consistently and coherently put forward in its discourse and in its actions. Now, we have a panel of very eminent people who will have a privileged position to give some comments or thoughts with respect to one or more of the presentations that we have just heard. So the panelists, the discussants are not necessarily asked to comment on each and every presentation or each and every aspect of it. They can pick and choose because they only have about 5 minutes to present their thoughts on what was being said. So we'll first have the panel discussion with our privileged interlocutors before then going into a discussion with the wider audience through the Q&A. Now, for the panel discussion, we have with us today in this session, first of all, Professor Michel Chang, who is a professor in the politics department of the College of Europe in Bruges, who is the only permanent or full-time professor in the politics department. Then we will have Philippe de Bruyker, who is a Germanic chair at the Institute for European Studies at ULB, the university, the French-speaking university in Brussels, and who's an expert also on migration and asylum. Then we will have Paul Nimitz, who is a visiting professor at College of Europe in Bruges, and who was a co-editor on the book on constitutional democracy. He's principal advisor for strategies for cross-cutting justice policies or legal actions at DG Justice and Consumers of the Commission. And then we have with us, and I would like to emphasize that we have opted to have in each panel as a discussant, a representative of the students of the College of Europe, because this is a conference on the future of Europe where we also want the young generation to be heard. The future belongs to them, after all. So we are very pleased to have with us also Ayoub Mahi, who will represent the politics students of the College of Europe here in this discussion. So if I may first ask Michelle Chung, perhaps take the floor. If you can each stick to 5 minutes, and the idea is to launch the discussion then also with the broader public. So Michelle, you have the floor.
Okay, thank you very much, first of all, to the organizers for this kind invitation to speak at the conference. And secondly, I would like to thank our panelists for a set of very interesting and innovative papers. And I think this discussion will be very fruitful. So thinking about where Europe was a year ago in 2020, when it was emerging from a period of multiple crises that it had been battling over the previous decade, from the Euro crisis, where we saw some familiar language that we hear now about the solidarity element versus the risk reduction and the responsibility element that we had heard earlier this afternoon. We had the migration crisis that had really been problematic in 2015 and still remains a very important policy for Europe. And we had the rule of law and democracy elements, which were simmering perhaps a little bit more than they had become even more acute in recent months. And then finally, we had the issue of digital regulation and the banning of Donald Trump from Twitter and from Facebook perhaps really underlined the impact that this has on democracy. So we already had been seeing a year ago a return to nationalism in many respects, as well as a return to some intergovernmental tendencies rather than European tendencies. And some had argued that the COVID crisis could reverse this, and we would see, more Europe as a result. And we saw some very interesting reflections in our panel today. And so I wanted to think more holistically about, what is the future of Europe? And I think, first of all, we have the issue of, well, what are the results of the policies that we're pursuing right now? From the economic recovery, that includes the next generation EU budget, to what will be the results of the digital proposals and migration proposals, as well as the rule of law. That all of this is really going to help determine what will be the future of Europe if we are able to go and properly make use of the existing tools. And if we are able to, as Andrea had mentioned, have the foresight to be anticipatory as to what the needs will be in the future. So Olivier had mentioned, for example, that the European semester's country-specific recommendations are underutilized when it comes to rule of law. And this is a very interesting and innovative proposal. That said, the European semester's country-specific recommendations do not have a great track record when it comes to their implementation already. So if we were to further put some additional burden on it, it's unclear whether this would bear fruit, given that it's already difficult for the member states to convincingly adhere to the country-specific regulations and go beyond what they were probably going to be doing anyway. When it comes to digital Europe, will it fulfill its expectations? We need forward-looking regulation. This is true, but this is perhaps easier said than done. Facebook, when it was created, it was primarily to help Harvard undergraduate students get a date. Now it's a destabilizing force for democracy. So trying to go and anticipate that, is quite a challenge for policymakers. And then if we think of the handling of the refugee crisis, as Elspeth had considered, we need a reconsideration of this push-pull theory that she had discussed, because this really impacts the narrative of the crisis and how citizens view it. And so the second element, aside from the results on where the future of Europe is going, I think is really going to also hinge on its coherence with European values and the European project as has already been described. So, for example, Andrea had asked if the digital sector can contribute to the EU sustainability and resilience objectives. How is this distinct, and how would this be different from a non-European strategy? And is there a trade-off potentially with economic growth? Elspeth, as I noted, had already talked about the narrative of the migrant crisis and the language that's been used and the burden sharing. This needs to be more coherent with European values, and she's absolutely right on that. And Olivier had noted the lack of cooperation between institutions, which also undermines the force and the impact that Europe can have if it looks like even its leadership is not on board or is at odds with one another. And so finally, with the appetite for Europe, are we going to go and see the resilience of existing European institutions? Will we see a retreat from Europe, so less Europe rather than more European integration? Or will the European Union be able to make a reconfiguration of where it goes in the future? And so with that, I think that the panelists have given us much food for thought. So thank you.
Thank you, Michelle. After the round with the discussants, I will of course give back the floor to the speakers and to react also to the comments that discussants have made. So, but I would first like to give the floor now to Philip de Bruyker to give his comments or insights.
Hello, everybody. Thank you very much for giving me the floor. In 5 minutes, it is, of course, absolutely impossible to comment upon the marvelous synthesis that Elspeth made. So I decided to comment, because the conference is about the future of Europe, about the new pact that has been presented by the Commission regarding migration and asylum on 23rd September. And I will take over 3 points about this pact, by starting firstly what it is not. And actually it's quite interesting to notice that the pact is not a programmatic document. We could have expected, after the failure of the agenda on migration regarding the issue of solidarity, a point upon which I will come back, to have a document for the future. And actually, we have a simple communication of the Commission, while it would have been possible to imagine to elaborate conclusions of the European Council, as Article 68 of the Treaty on the Functioning of the European Union provides a legal basis for adopting guidelines for the legislative and operational programmation of the European Union. But instead we have a simple Commission communication. And secondly, what the pact is also not, it's not a document expressing a new consensus, while it would have been really necessary to try to elaborate a consensus, in particular regarding solidarity. But when you look about what is proposed in the pact regarding solidarity, you have actually an alternative which is proposed by the Commission. Either the member states do relocations, so they resettle within the European Union asylum seekers or refugees from countries that are overburdened. Either they do a kind of, they sponsor a return, meaning that they help the countries overburdened by returning persons staying illegally or rejected asylum seekers to their country of origin, for instance, by helping to organize a flight to the country of origin of those migrants. So an alternative between these two options. And what is, of course, then I think remarkable is that this alternative is totally incoherent, because on the one hand, you have relocation of persons within the European Union, and on the other hand, you have returning people to their country of origin. So these are two opposite and contradictory elements between which the member states can choose. And that's, I think, absolutely not a consensus, but an amalgamation of two contradictory elements. Of course, one could have thought that this would please the member states of the V4 group, the Visegrad group, but actually, no, they disagree with the idea of return sponsorship that they consider like a kind of relocation of illegal migrants within the European Union. So actually, I think that this pact is now already in a very bad position. It seems German presidency has not managed to get an agreement about its main elements. And regarding solidarity, which is the core of the pact, it seems that it will be rejected even by the V4 groups, despite the fact that they are offered that opportunity to return migrants to their country of origin. So that's unfortunately, I think, a very bad beginning, and I don't want, of course, to predict the future, but that very bad beginning allows us to think that the pact might fail. And that would be the second failure after the agenda on migration and the proposal to change the Dublin regulation, which was called the Dublin IV proposal. So we can, I think, be worried for the future of the European migration and asylum policy, and think that we really need something else than this pact by thinking of a long-term programmatic document for the future of the European Union. Thank you very much.
Thank you very much. I'm sure that Elspeth will probably take up some of the comments that you have made later on. Let's first go to Paul Nimitz. Paul, are you with us there for his comments?
Absolutely, Inge, thank you very much.
Good.
I would like to thank Olivier de Schutte and Andrea Renda for their excellent presentations. I think it's important to see the rule of law and democracy debate on the one hand, and on the other hand, the shaping of the digital space through legislation together. Because we are shaping the future of democracy and the functioning of the public sphere, the electronic public sphere, through this very technical legislation, which on the forefront looks like related to technology, but actually that will be determining how the rule of law and fundamental rights delivery, but also democracy and discourse and the press as force as state will function in the future. Now, as to the presentation of Olivier, let me say that the Parliament has also doubled the amount of financing in the new financial perspective on rule of law and values from 350 to 700 million. So in DG Justice, we are preparing. And I just mentioned this because money is important in this area. Europe being young as an actor on rule of law and democracy still, I would say in the past has been quite shy in using this tool, but probably people start to understand that you cannot bring democracy and engagement into societies through legal process and the Court of Justice only. And that is actually a very German experience. After the Second World War, billions of euros have been invested into political education, and even today the big political foundations which every party has an independent foundation which is not allowed to do party work, which is closed in terms of the world view. Each of these foundations get around 100 million euros still today a year for political education work. Compare it to the foundations on European level, the Martens Foundation for the EPP, FEPS for the Socialist Group, and so on. They get, I think, around 4 million each. So it is important that we recognize that we have to invest not only in hard infrastructure and so on, but beyond qualifications and knowledge, we have to invest in engagement and political education. Without that, things will not go the right way. I would also say that the democracy initiative of the European Commission should have been mentioned. It is on the forefront. It is a document of programmatic nature, but it announces legislation which is very specific to democratic process. For example, rules on the transparency of internet-based election propaganda and advertisement to make transparent how people are micro-targeted in these processes. And I would say also overall, one has to read that document together with the whole raft of legislative proposals which are now on the table to regulate the digital, like the Digital Services Act, the Digital Markets Act, the Digital Governance Act, and certainly also the forthcoming AI regulation. And then one gets a perspective on how we are trying, let's say, to bring aspects not only of fundamental rights and rule of law, but also of democracy into the digital space. The challenge here, and this is a new type of complexity, is that we have to develop, all of us, an understanding not only of the mechanisms of law and democracy and fundamental rights and the rule of law, but we have to merge that understanding with an understanding of what the regulation of the technical sphere means for these areas and how you can use this regulation to ensure that democracy, rule of law, and the delivery of fundamental rights in the future works. And there are very few people, and I have to admit, I've also a huge challenge, who are able to master this. And I think what we need here is more of an interdisciplinary dialogue with people who understand technology, not only to gain their knowledge, but also to draw them into more political engagement. We need the technological sphere, the technological intelligentsia, whether digital rights activists or people in development of software and technology and so on. We need them to come back into the political process and political institutions. The number of engineers in our parliaments all over Europe, in the European Parliament, even also in the US Congress, has consistently declined over the last 20 years, while power over society of this group, and by the way, also the number of people working on digital technologies, has enormously increased. So, and we need to instill in this group and in society beyond that also a better understanding that the rules of society, of democracy, and how law works are completely different than the principles of functioning of software, computers, and digital networks. Because that is the big misunderstanding sometimes in the Brussels debate, that we just have to adapt the law to the principles of the digital, and that will solve all the problems. And this are sentences like, the law has to evolve as fast as software evolves, which reveals a huge misunderstanding, but a misunderstanding which gains ground and which is pushed forward also in the legislature, in the European Parliament, and I would say even in the other institutions. And I think our job as lawyers, political scientists, and those who understand that we are working with language, is to go out there and first to rehabilitate the law as an instrument, as distinguished from the doctrine of the unregulated, unbroken global internet and doctrine of technology solving all the problems. I think we have seen in America now that is accumulation of all the challenges which technology cannot solve. I think it's a moment of recovery, of a return of law as the most noble instrument of democracy, and we should not be shy to use it. Secondly, we have to make it clear that we need a new type of legislation which is open enough and technology neutral enough to stand the test of time also when technology moves fast. So what I mean by that is we need to have legislation which does not require changes every time the business model or technology changes, but which allows a reinterpretation by humans based on the open formulation when innovation moves on. And that is, by the way, a big misunderstanding of the engineering world. You know, software is written for stupids. And who are the stupids? The stupids are computers who can't think themselves. And that's why you constantly have to revise the software, while the law is written for the humans, which can think themselves and have the ability to reinterpret the law if technology or business models change. So I think these are basics which we have to bring into the debate as lawyers and political scientists. Beyond that, for the future of Europe, I would think we need to work on tools for a democracy which defends itself, and also we have to dare more democracy in Europe, in this that we must equip the European Union through this conference on the future of Europe with the instruments to also have more impact on instilling democratic process and ensuring democracy in member states. So my wish personally would be that we start work like we did it a long time ago on the Charter of Fundamental Rights, which started as an informal document and only slowly moved up, first through commitments through individual institutions, and then finally was taken up in the treaty. I think we should start work in the future of Europe conference or afterwards on a Charter of Democracy, which focuses on democracy in member states. That is the old debate which we had here in the college constantly was how to democratize Europe. That is still an important subject, but I think we have made great steps forward. The new challenge is democracy in the member states. And so there I would say we should work on a charter on democracy, which we hope then eventually member states and the union together sign up to, and which equips the union to have more impact and more instruments to ensure democracy in member states in a certain way, reconciliating and bringing together all the instruments dispersed in the OSCE, in the Council of Europe, and so on, where there's a lot of lack of coherence of activity. And the second thing I think the Commission may be moving towards is also something of like a democracy mainstreaming of its proposals. There is a huge potential in the legislation we on European level, which is of very sectoral nature, let's say in transport, government procurement, environment, migration, to seek for a method of legislation which opens up space for participation in its implementation and enforcement in the member states, to open up the scope for civil society participation, to open up the participation also in the enforcement and application and implementation process for citizens. We can, through our legislation, impact democracy in many areas in the member states. After all, 80% of the economic legislation is EU legislation today. So if we make it a plan that in our sectoral legislation, we actively always seek to maximize scope for living democracy, for space of civil society in member states, that can make a huge progress. And the good thing is, the Commission can do this on its own initiative. Thank you very much.
Thank you very much, Paul. This Charter of Democracy, let's hope it doesn't take that much time as the Charter on Fundamental Rights did. Otherwise, I think it's a good proposal. Let's first hear now about the students' vision, and Ayub will also give his comments and insights. Ayub, I cannot see you on my screen. Are you there?
Yeah, I'm here.
Okay, good.
First of all, thank you very much to College of Europe and the European Law Journal for this opportunity. Such an honor again to represent Pole students. I am a Moroccan student and I will be talking about my beloved region, and I will be providing fact-based answer on our session main question, what kind of political project? And I will be also based on migration and youth in the context of the external action policies for the Mediterranean region. So the Southern Mediterranean region remains one of the least integrated in the world, and the UFM have reported that 90% of the Mediterranean regional trade is between EU member states, 9% between North and Southern Mediterranean, and only 1% between Southern Mediterranean countries. The Mediterranean cannot continue to be presented solely as a graveyard for undocumented migrants. The challenge in the Mediterranean cannot be limited to the fight against religious radicalism and terrorism, with the conflection of issues that gives this rise of suspicious and mistrust between people. There are 800 million people in this region, and a large majority of them are young, like me, who share a common space and collectively this collective reality on a day-to-day basis. The solution for me lies with the horizon and the taking the potential and talents of young people across the region. Europe might be an aging country with older people make up to 28.5% of the EU population by 2050, but Southern Mediterranean is not. There, older people are less than 10% of the population in all countries, and between 24.7% and 38.9% of the population, depending on the country, of course, are in their 15 years old, and in the EU, only 15.6% of the population is under 15. In 2017. So one of the main examples of the regional youth activism is One Youth, One Sea initiative. This refers to a group of young people who are coming from across both sides of the Mediterranean and who took this initiative to actually form their own media resource, writing articles about what mattered the most for them. And in 2017 follow-up, in their initial 2014 appeal, they highlighted the variety of projects relating to job creation. This piece also called for reforms favoring SMEs, innovation, improving education, and these priorities are actually broadly shared by youth in both Europe and the Arab world. So I kind of call for a moving beyond this security measure for a more positive strategy, which also centers primarily the socioeconomic issues. In Europe's recent elections, we saw this youth surge in their pining, the turnout increase. The Eurobarometer also found that the top 3 issues that matters for the citizens were the economy, climate change, human rights, and democracy. But migration actually landed in the 5th place. These findings chime with the special youth Eurobarometer from 2017. When asked to name 3 topics they thought they should be a priority for the EU, young people's top 3 priorities were education, skills, protecting the environment, and combating climate change and employment. Migration also came in the 4th place, hardly. In the Arab world, young people share the same opinion. The Arab Youth Survey 2019, covering 18 to 24 years old in UAE, Oman, Bahrain, Saudi Arabia, Kuwait, Egypt, Jordan, Lebanon, Morocco, Tunisia, and other Arab countries, they were also asked about the varieties of issues facing the Middle East and North Africa, and the top concerns among Arabs about the MENA region were the rising cost of living, employment, education, and the slow economy growth. And the threat of terrorism came in the 7th place. So for me, as a conclusion, what kind of political project? I think that the youth on both sides of the Mediterranean share these same concerns. At a time where the EU is restructuring its external action funds and the Marshall Plan for Africa, I mean, it should also reassess its external action policies. Young people from both sides of the Mediterranean have a new positive version of their region, which transcends with the narrow focus on migration and security and defense. The European Union should support them with a more holistic approach and a genuine partnership which centers the concerns of youth, not the concerns of populists. Thank you very much.
Thank you, Ayub. And with this plea for listening more also to the young people and what their projects are, I want to give the floor back to, first of all, our speakers. I will ask them to reply in reverse order. So starting with Elspeth Gill, then Andrea Renda, and then Olivier de Schutter. And then I will again give the floor for a brief comment, if you wish, to the discussants before passing to the Q&A. So, Elspeth, do you want to react? Migration has been, or third country nationals has been mentioned quite a lot also in the discussions. You have the floor.
Thank you very much. And thank you very much to all of the commentators for really interesting suggestions, developments, ideas, and reflections on migration in the European Union. I think the first thing I would say in response to Philippe is I'm very reluctant to start talking about the V4 versus the rest, the Visegrad 4 versus the rest. There is a tendency now in some policy circles to say, well, we could have progress, whatever progress means in this context, if we could just ignore the Visegrad 4. Because they're anti-migration, because they're whatever. And I think this is a very bad idea. First of all, I think we must remember that the member state which issues by far the largest number of residence permits to third country nationals every year, according to Eurostat, is Poland. It is not Germany. Poland issues very large numbers first residence permits to third country nationals, and of course the nationality of those people is primarily Ukrainian. And of course, no one in the European Union wants Ukrainians applying for asylum on the basis that Kiev can't protect them. So issuing them residence permits is of course a solution. What was the EU's response to the issuing of very large, a few million, first residence permits every year to Ukrainians? It was to lift the mandatory visa requirement from Ukraine. So Ukrainians could just walk across the border, take a bus across the border, and they would not be illegal or irregular migrants. They could just walk into a job center in Poland, apply for a temporary residence permit, and take up work. So to demonize the V4, I think, is problematic. The whole idea of somehow relocation, that relocation is going to work, is based on the idea that people are like tins of beans. You can pick them up from one place, put them down in another place, and they'll stay there no matter how bad the treatment is. So, you know, if the tin of beans is being hit over the head, it'll still stay there because it doesn't have any agency to move. But if you have really horrible reception, with asylum seekers being beaten up on the streets, not being provided any housing, not being provided access to health services, pregnant women being spat on in buses, of course those people are going to move on. They have agency. You send them to a country with a poor reception system where asylum seekers are demonized, and of course they're not going to stay because what they want is a life which is a welcoming one. So I don't think we can resolve the problem with relocation because people move. They're not tins of beans. And if you send them somewhere that's horrible and where they're treated very badly and put up in military, deserted military bunkers, they aren't going to stay there. They're going to leave. And I think there's also a myth about expulsion. Certainly in the legal world, those who look at national expulsion decisions of the member states explain the difference between the number of expulsion decisions taken and the number executed by the very, very poor quality of expulsion decisions. So making an expulsion decision in some member states is a knee-jerk reaction to going and looking at a file rather than going and looking at a file, seeing what the situation of the individual is. And so many of those decisions are ultimately reversed. And that's what explains the limited expulsion numbers. But what the pact proposes, and what we're seeing, is that the officials who are taking expulsion decisions with a careless and a failure of due diligence in respect of the facts will no longer be responsible for what happens to those people, because expulsion will be handed over to another institution, probably Frontex, who will be given names and said, well, just send them out. And so there will never be a control over the inadequacy of the first decision. And I think that this whole idea in the pact of relocation or expulsion being paid for by somebody else, being done by somebody else, is doomed to failure. Is failure a bad idea? Wouldn't it possibly be a good idea if we did nothing in immigration and asylum except try and bring those member states who are still applying intra-Schengen border controls to lift them, and leave this area as a policy field for the legislation adopted since 1999, and particularly since 2011, 12, and 15 in the Common European Asylum System, to settle in and embed. We did this with free movement of workers. The old regulation 1612-68 was in place from 1968 until 2004. Leaving it to bed in made free movement of workers a reality, because it wasn't being changed every 5 seconds. Officials, judges, lawyers, individuals learned about their rights, learned how to correctly apply it, and it had a proper period of time to resolve. I would like also just to come back to the comments of Ayub, because I think they're particularly important. The way in which certain parts of our extreme right, that right which brought down the Belgian government over the Global Compact on migration is an example, are allowed to get away with demonizing the MENA region, and young people in the MENA region needs absolutely to be displaced. One of the best ways of doing this is to extend much more in terms of educational and cultural exchanges, ensure that everywhere across the European Union, young people from the MENA are participating in programs and activities. You are our neighbors. Why do we not treat you with the same respect that we treat to the Ukrainians? And we need to reverse this imbalance in the way in which the MENA region is seen as the source of all trouble migration related for the European Union, instead of seeing it as a neighbor just like any other neighbor with whom we should have good relations, and we should be fostering exchanges. Thank you very much.
Thank you, Elspeth. Andrea, would you like to react?
Yes, sure. I have a few comments. So thanks for all the comments that were also mentioning the importance of the digital sphere, and also I think broadly converging with the idea that in and of itself, the way in which it has spontaneously developed until now, that the cyberspace is not potentially going to be particularly say aligned with the direction that the EU project will take in the coming years, so that some mutual rapprochement has to occur. But at the same time, what is rather new is that there is a shaping to be made of the digital environment that requires a proactive attitude, in particular by the lawyers. Because it is the law that has to change. As Paul was mentioning before, I can make an example, meaning the first all-encompassing comprehensive regulation on artificial intelligence in the world will be proposed by the European Commission at the end of March. No other country in the world has regulated AI in all its potential uses. There have been regulations for use of AI in government or directives like in Canada, but indeed this is a first attempt. Now, when I was assisting the European Commission in the impact assessment of that regulation, I realized how difficult it is to make that jump. The definition of AI was unclear until the very end, and actually was not technology neutral at all until the very end, which is a problem, right? Because AI changes skin on a weekly basis, and you cannot just point at specific ways of doing AI, because by the time the Parliament and the Council reach an agreement, you basically are already outdated. At the same time, the text of the regulation, as I saw it shaping, was extremely prescriptive. What uses were possible or were presumed to be maybe potential violation of fundamental rights or safety were listed in the regulation or in an annex, depending on the version, in the gestation and in the elaboration of the regulation. And that is also impossible, because it again declares the obsolescence of that regulation the moment it sees the light. Eventually, it might be unfit for purpose. So the idea of being very prescriptive in the regulation is something that has to be abandoned over time, and rather what kind of instruments do we use in the law? Do we rely on the court? Do we rely on ex ante controls? Do we rely on sort of risk governance and overall accountability and responsibility of players for constantly monitoring the market? And that is something that requires completely new tools. And this leads me also to the overall overarching question that I was posing regarding the EU project in and of itself as a political project. The Conference on the Future of Europe has been presented also as chiefly a way to bring citizens closer to the EU level, to EU institutions, and provide suggestions. Do you want to organize a debate on current social media about that? And what would be the level of trust that we would place in the dynamics of current social media, where an estimated 60% of the let's say individuals that we see are non-human, and where the dynamics are completely out of control, as was mentioned also regarding, for example, the Twitter blocking of Donald Trump, which is a very interesting example of how private power, regardless of how sympathetic you are with the case, but how private governance and power are now predominant in that sphere, right? The potential change that needs to happen is, if we really want to organize a forum for debate on the European Union that uses and leverages the outstanding potential of digital technology, we need to fix the interactions that take place on digital technology. And we need to maybe use digital technology to make a step forward. One example, and then I'll close. Digital technologies, but also more generally, I mean, the political process has shown increased degree of polarization over time. So bringing citizens into the sharing of ideas and the co-creation of future EU policies means certainly doing something that is intuitively appealing, but at the same time, it means bringing to this forum the behavioral biases, the echo chambers, the short-termism of citizens. And organizing a debate under these conditions is not particularly meaningful, in my opinion. Still, using digital technologies, for example, to induce more empathy in citizens, or to motivate them to interpret why other people might think differently, or to motivate people to, or to sort of increase the salience of long-term impacts, and at the same time increase the salience in their reasoning of the potential existence of groups in society which have a specific condition that needs to be taken into account, what we sometimes call empathy in policymaking. Doing this is something that the digital technologies can do, but it's very far from what digital technologies today do. So again, the invitation is, let's try to work together to use digital technologies for good, but this will require an enormous amount of work, an enormous amount of flexibility, even by lawyers, which are not normally praised as being the most flexible people in the world, but I think they can be. And also the ones that really understand the law, they understand that it has to change depending on the underlying dynamics of the subject matter that needs to be legislated upon and regulated. So thanks. Back to you, Inge.
Thank you very much, Andrea. Just one thing on the prejudice against lawyers. I think if you look at the case law of the Court of Justice, you will see that the court has been extraordinarily creative in inventing the law, even, so that the lawyers are also capable of reflecting on solutions. Okay, Olivier, you have the floor to react to the comments.
Thank you. And of course, my sincere gratitude to the different speakers from the panel and to my co-panelists, Andrea Renda and Elspeth Gild. Let me perhaps propose 3 remarks in response. First, Michelle Chang quite rightly noted that the country-specific recommendations addressed to states under the European semester process were not systematically complied with. And it's true that in some areas, not least when these recommendations concern social rights, they are often disregarded. This, however, is likely to change, at least in the next few couple of years, given the links between Next Generation EU and the CSRs. In fact, one striking benefit from Next Generation EU and the way the Recovery and Resilience Facility shall work is that these CSRs are now tied to access to European funds more strongly than ever. And so I suspect that it is a tool that could be used if we want to use this, if there is a political will to do this, to strengthen the rule of law by ensuring that no funds go to states that are disregarding these recommendations. And it's easier to do that than to use the general regulation on the suspension of funds in case the rule of law is disregarded, the regulation on general regime of conditionality for the production of the EU budget, simply because it places the bar less high, and it will be perhaps less visible to the public, which means governments may find it easier to adopt compliant and face-saving strategies. Secondly, I would like to thank Paul Nimitz for very usefully pointing at perhaps what is a 5th tool in the hands of the EU to promote democracy, the rule of law, and human rights. And he referred to the action plan on democracy, the democracy initiative of the European Commission. And I think it's extremely important. And although I was not aware of the example of political education work in post-Second World War Germany, I think it is extremely instructive to see how it created a culture of respect for democracy and human rights in that context. However, I do see, like many others, and like certainly Paul Nimitz himself, the urgency of addressing the situations we have now in Poland and Hungary, and I fear that it will take time to build a stronger support across Europe for democratic values. The problem today is not that the opinion is against democracy, although we do have fake news, we do have extreme right-wing groups, we do have threats of that nature. The major problem is with the leaders in these countries I've cited, not with the population that is not unilaterally, certainly siding behind or completely siding behind those leaders' choices. And the immediate objective is to ensure that the next elections in those countries will not be influenced by Poland controlling the media or the Hungarian government changing the rules of the elections. So I think there's an urgency here, which the other tools I've mentioned should be better equipped to address. And finally, I'd like to thank Andrea Renda and those who addressed his presentation for making the link between the digital space and democracy. It is very important. And of course, Vera Jourova, the commissioner responsible for EU values, is very committed to ensuring that fake news, disinformation is not publicized or disseminated by the platforms, and she has made proposals in this regard that I think are interesting. It is indeed very important to stay ahead of the game if possible in these areas. as I think Andrea quite rightly emphasized, regulators always arrive a bit too late in comparison to the practices of the users of the technologies, and indeed of the big economic players that are behind those. So it's not an easy battle to win, but it's certainly one that is worth fighting. Thank you.
Thank you very much. I don't know if any one of the discussants would like to speak up again at this point to react to what has been said. No, if no one grabs the microphone, then I propose that we go to the Q&A session. And then, of course, everyone will have the opportunity again also to intervene. The Q&A session, Karin Koons has been looking at the various questions that have arrived through the Q&A at the right hand of your screens. So Karin, I propose that I give you the floor to sort of assemble a couple of questions and to address them to the speakers and panelists alike. Karin, you have the floor.
Thank you very much, and thank you very much for your enlightening and very thought-provoking presentations and reactions in such a short amount of time. So we have questions on different themes, so I will just send you, tell you what the questions are, and you can choose to which questions you wish to answer. So one about the rule of law and still the issue of the European semester. How could the European semester be improved to be effective as a rule of law enforcement tool, apart from what you already mentioned? The implementation rate indeed so far is pretty low. A second question, which is more general, linking rule of law issues and migration asylum issues. The principle of the rule of law and asylum policies stand at the core of what democracy means today. If the EU fails in the enhancements of these two fields, being unable to enforce the rule of law and to reform the Dublin system, should we conclude that the EU itself has failed in the end? As far as migration is concerned, Ms. Elspeth Gild spoke inter alia of Schengen. What is your opinion on the viability of the Schengen framework under the pressure of COVID-19? Do you agree that unilateralism has research in the EU and that insufficient counterweight has been given by the EU institutions? Do you share my concern that mutual cohesion within the EU is at stake within the field of justice and home affairs? Another question in the field of migration. Can we seriously say that the EU respects basic human rights when we see how the migrants and refugees from Africa and the Middle East are treated by Frontex and by most of the EU member states? And one on the digital theme. The COVID-19 pandemic changed a lot of things in our lives. Has the pandemic shown problems, issues, or new challenges which were invisible and unpredictable prior to the crisis, the COVID-19 crisis, as far as digitalization is concerned, and more particularly regarding the EU?
Okay, I propose we take those questions as a group. I don't know if Elspeth and Philip would like to answer first on migration, perhaps because there were several questions there. Elspeth?
Sure. And very good questions they are. Thank you very much to the audience and providing me with an opportunity to develop a bit on some aspects that are very interesting. On rule of law and asylum, I think we should probably avoid the term failure. The European Asylum Support Office, an EU agency, has been telling us for years that only 3% of asylum applicants in the whole of the European Union are ever subject to a Dublin return to another member state. So we know that the main places where asylum seekers come in tend to be the southern borders, other than many asylum seekers who arrive by air, but we'll leave that aside. And they move on because they receive a poor reception, or they have friends, or they have family, or they think somehow things are going to be better somewhere else. and they self-relocate. And that's the vast majority of them, and only 3% are ever going to be returned. So if this has been the truth of Dublin since our very first Dublin Convention in 1990, is it appropriate to talk about failure now? This is what the system does. This is what it's always done. And there's never been any substantial change, notwithstanding all kinds of statements about how we're going to make Dublin work and it's all going to be fine. But the problem there is, of course, the can of beans problem. You can move a can of beans and it stays where you put it. You can't move a person and keep them there if they're being treated badly. So I think that it's not helpful to talk about failure. It's more helpful to talk about how should we go about recognizing self-relocation. And that would be more useful to the rule of law. Or we could just leave everything as it is and accept the fact that people will self-relocate, and that if we don't want them to self-relocate, then it's for the Commission to actually enforce and start infringement proceedings against member states which do not comply with the Reception Conditions Directive. If there were proper housing, if there were proper support, health services, education for asylum seekers arriving in Greece, if they were not living in tents in Moria and subject to the most vile behavior, then more asylum seekers would probably stay in Greece. We need to work on the reception conditions side, and it's not, once again, the Commission has put on its website all of the figures of how much money has been given to Greece to make the common European asylum system work there, and it's astonishingly enormous. It would reduce the national debt substantially. Migration, COVID-19, and Schengen. Schengen has taken 3 big hits. It's taken a hit in 2015-2016 because member states wanted to protect their reception conditions from the arrival of more asylum seekers than they anticipated. It took a hit again in the end of 2015 by a small number of member states that had a real problem about terrorist incidents, and somehow reintroducing border controls seemed like a good idea, even though the relationship between terrorism attacks and border controls is unproven, to put it at its very mildest. Now it's taking a 3rd hit on COVID-19, closing borders. And the purpose of closing borders in COVID-19 is to protect our health service infrastructure, our hospitals, from being submerged by people possibly from other member states or who are bringing the COVID virus with them, and then will need help in our member state. So the common position between 2015 and 2020 is introducing internal border controls to protect parts of public infrastructure. Is this successful or is this not successful? Is this helpful or is this not helpful? Well, I think there's certainly enormous questions to be asked about that. We've seen many countries just increasing their infrastructure, their public health infrastructure, to deal with the COVID-19 pandemic. Do border controls work? Well, they might slow things down a bit, but they don't do much more than that. Is this going to be a long-term challenge to Schengen border control free movement in the European Union? Personally, I think it's unlikely, mainly because much of the so-called closure of borders, whether it's for the movement of asylum seekers, whether it's for the movement of suspected terrorists, or whether it's the movement of persons who, when there are concerns about whether they're carrying COVID-19, is symbolic rather than practical. An enormous amount of cross-border movement across the EU is taking place in the international haulage sector, where the movement of food services, food products from, for instance, Spain to the north of Europe has doubled and tripled during the COVID-19 period, where migrant workers, migrant seasonal workers to carry out harvests have gone up massively as people are stuck at home. And therefore, actually, we've seen more cross-border movement, fewer controls at borders. There's an exception, of course, on the Polish-German border in the spring of 2000, when that border got completely out of control with backlogs on the land borders running for 12, 14 hours, which of course are prime conditions for the transmission of COVID-19. So do we think this is going to be long-term? My suspicion is no. If one looks at the Eurobarometer surveys on what do people like most about the EU, what are they happiest about, it's about free movement. And it's about being able to just move and go on holiday, go and work, go and study. These are at the very core of what European citizens want from Europe. And I would not give much chances to a political party in any member state which began to say it was going to take all of those rights away from them again. I think with the UK and Brexit is probably the one and only exceptional to that. Respecting human rights, yes, the demonization of the Middle East and Sub-Saharan Africa is an enormous problem. In discourses in Europe, the treatment of those borders in comparison with the treatment of the border, for instance, with Ukraine is extremely difficult to justify in terms of human rights and our various considerations. And I think that if we could start promoting cultural exchanges, educational exchanges, much more cultural person-to-person contact with the Middle East and with Sub-Saharan Africa, we might be able to get over some of this terrible prejudice, which is a blight on the reputation of the European Union. Thank you very much. I've run on for a rather long time. Sorry.
No, thank you, Elspeth. It's very difficult issues, and it's good to spend some time on those. I don't know if Philippe wants to add something on migration here.
Yes, very, very briefly. About COVID and Schengen, I agree with what Elspeth says. Actually, we should not be worried because all the internal border controls that have been reintroduced to fight COVID have disappeared. Now they come back here and there, but they will not stay. And that's a bit different from the reintroduction of border controls that took place during the previous years about terrorism on secondary movements. There we see some controls that remain and that are more problematic. Second point, to react to what Elspeth has said about, for instance, the transfer of the return policy to Frontex, being clear that it's the transfer about the implementation of national return policies and not of decision making. Well, I would say, why not? I think that it's a way to Europeanize this policy, which is an absolute need, and that agencies are part of the solutions because they are a vector of solidarity. If Frontex is taken over the implementation of return decision, it will help some of the member states that are overburdened. And by the way, it would also have raise a very interesting question, because we will then see if Frontex is or not more successful than member states. And then we could really draw conclusions about what works and what doesn't work about return. Thank you.
Thank you. Ayub wanted to react on this? No. Okay, sorry, I misinterpreted. Unfortunately, Olivier de Schetter had to leave us for another very important meeting on poverty in the European Union. I don't know if Paul Nimitz can answer the question on the European semester and the rule of law.
Well, I can say that DG Justice is very active in the European work, and has rightly discovered that that has been a tool for us already for some time. The limitation is that it, on the face of it, economic purposes. So we have developed a certain skill to dress up concerns related in particular to the rule of law and sometimes also fundamental rights and discrimination as economic concerns. And I would say, while it is true that the effectiveness of the instrument can increase in the next financial period due to the link described by Olivier, there are inherent limits due to its overarching economic purpose. I would just like to answer to two questions which I saw in the in the written questions, namely one, what will be the issues on AI which will be discussed most in the legislative process? I think there will be two issues, namely first, the question of coverage. Which companies should be obliged and which types of AI in terms of risk should be obliged to be complying with part or all of the obligations put down? Should we have some general rules which are cross-sectoral, basic rules on AI, such as, people always need to know whether AI is speaking to them or writing to them or taking a decision? Or should we only have rules in certain sectors of activity? So I think these will be the two key issues. Which risk groups and sectoral or rules which are horizontal. And I have seen another question which I thought I can say a word of, but now I've forgotten. So maybe someone else can move on.
Okay, I think Karin will come back to us with the questions, so okay. You don't have to read them. Karin is taking care of that for us, fortunately. But perhaps Andrea wants to come in on the digital and also on the artificial intelligence.
Yeah, maybe because COVID and the digital world, maybe I put them together. I actually would like to start making a sort of drawing a link between the discussion that we've had also with Olivier Schutter and about the questions on the semester and COVID. Indeed, we have seen as a result of the pandemic is that the Commission has gradually shifted its overall set of targets and principles, and also the criteria that will be used in the semester and in the assessment of investments under the Next Generation EU, from the initial approach of the von der Leyen Commission, which was already very much oriented towards sustainability, towards a more comprehensive set of indicators that incorporate what we call resilience. So the ability of society to absorb shocks, the ability of society to be reactive. And what is encompassed under the concept of resilience has a lot to do with technology as well, and I'll get back to this in a second, but also has a lot to do with the rule of law, inevitably. As society is more responsive, as society is more able to interpret change, as society is more able to organize itself when it's subject to good governance and when the rule of law is respected. And I think one thing that the Commission could do is to draw this link more precisely between the concept of resilience, which has become a buzzword over the past months in public policies at the EU level, and the rule of law. On top of this, I think since already in the European semester, the Sustainable Development Goals have been mainstreamed under Commissioner Gentiloni, and in principle, the country-specific recommendations should increasingly mirror what I call an SDG plus, let's say, agenda, so including this idea of resilience and perhaps incorporating rule of law. I think the use of conditionalities can become more important, more meaningful, and perhaps also more impactful in the European semester. Now, to do this, in my opinion, it would be very important to really close the circle between the imposition, well, the country-specific recommendations, the potential application of conditionalities in the evaluation of the disbursement of funds under the MFF, but most importantly, the Next Generation EU, and the unit existing now transformed in the Directorate General, which is the unit called DG Reform today, that is in charge of, so far, under more voluntary applications by the member states. So far, it's in charge of sort of overseeing and accompanying efforts by member states to strengthen their governance and the institutional reforms. There is a missing link in that circle that I think the Commission should try to fill and complete and in the coming months and years to fully realize its project. Now, that said, what has COVID taught us in terms of the digital technology? Well, I think that many of the things that we're identifying as problems have become emergencies. Meaning the fact that on the formation of individual preferences and the access to information was not entirely, let's say, unbiased, or actually was heavily manipulated by the online environment, was a problem when the internet was one of the many means that we were using to collect information. As we move our lives online, obviously, this becomes an absolute emergency, because as we've seen, the amount of disinformation and the as skyrocketed, let's say, and over the past year on the internet, and this is obviously transforming again that policy priority into a public policy emergency that requires the actions of the public sector, but also the private sector. The other thing that I think we have learned from the COVID-19 is that governments can use technology in many ways. Many governments, for example, have evoked the introduction of contact tracing apps as the panacea that would solve the problem of social distancing and avoiding the spread of the infection from COVID-19. Indeed, for technology experts, it was, in my opinion, pretty clear from the very beginning that there was no chance that contact tracing apps, unless really a miracle would happen, that everyone would download them, or at least 70% of the population would download them and actively use them. There was no, according to many, absolutely no chance from the very beginning. I myself told Jourova directly at the very outset of COVID-19 that there was not much faith to be placed in contact tracing apps as the one-size-fits-all panacea that would solve that problem. Indeed, the suspicion has emerged gradually that governments were more using this idea of the contact tracing apps to gradually collect more and more information about citizens, rather than really being able to enforce social distancing. Now, the issue has become more complicated because while governments wanted to introduce contact tracing apps with what we call a centralized architecture, so that they could have access to the data, as the moment one would test positive, they would be able to do tracking and tracing and finding other people that had been in touch or within Bluetooth range of this person that tested positive. The tech community bounced back by saying we want to have a decentralized architecture which is more privacy preserving, and we don't want the information from the contact tracing apps to be directly available to governments. And this is obviously more privacy preserving, but at the same time makes the contact tracing app completely useless, because I don't think any of us that needs to go to work one day would, unless there is a governance built around this, decide that it's legitimate not to go to work because your phone told you so, out of information that you cannot verify, out of an indication of time, space that cannot be fully disclosed. So the issue that we've realized there is that while decentralization of governance and perhaps having more points of control in the governance, including local ones, is perhaps a democracy-enhancing feature that technology can bring toward the organization of our societies. Indeed, pure decentralization in most cases means that whenever there is a superior public interest, we cannot activate those superior public interests unless we build the overall governance and legislation and public policy initiatives around this idea of decentralization. And in my opinion, this is something that we will not do for the next 4 or 5 years. Meaning you need to, and that is, in my opinion, something that increases the challenge in building democracy on the basis of decentralization, which is an important challenge for Europe in the years to come. Finally, on the AI regulation, I'll try to be short. What we expect is a regulation. We will be a proposed regulation. It will be a regulation that is based on an idea that you can distinguish artificial intelligence solutions between high-risk ones, so use cases or solutions, and non-high-risk ones, which is already problematic. For those high-risk ones, there will be the imposition of a number of regulatory requirements, which come with basically are those regulatory requirements that are identified in the white paper on AI, published on the 19th of February 2020. And this will be done with a system of conformity assessment, meaning that AI solutions that are designated as high risk would need to undergo conformity assessment. And that is also problematic because conformity assessment is essentially an ex ante control system. And AI generates risks that are in some cases visible before you place it on the market, but in most cases much more visible after you have placed it on the market, because AI systems learn from the online world, they adapt to other AI systems, they interact with humans. So this will be a first attempt, but it will be an enormous challenge in the AI regulation to make sure that you can not only control AI systems before they reach the market, but most importantly, attribute responsibility and accountability to anyone who develops, deploys, and continuously uses AI as AI is on the market, as those specific AI solutions are on the market. So it will be a regulation that will challenge us, I think, bit by bit to completely revisit what is largely an ex ante control system that we have largely in risk regulation, especially in the EU, into an ongoing monitoring system that obviously has the challenge of potentially ushering into surveillance. But at the same time, it needs to be done in order to ensure that we govern and manage and monitor risk generated by AI applications over time. Whether I have a solution to this, I would say I actually don't have a solution on how we will manage this walking on the tightrope in between observing everything to be able to monitor and observing only what is needed to preserve the stability of the market and the mitigation of risks, at the same time respecting the private sphere and the intellectual property of the companies that populate this market. So it's for another conference, not even Inge, maybe not even next year, maybe in 5 years we'll be discussing those issues, I think, more in depth. But I think it is something that I see coming, and for lawyers and experts in regulatory governance, I think it will be a key challenge.
Thank you. We still have a couple of questions coming from the audience. Karin will tell them in just a second. We have about 15 minutes to finalize this session. So I would ask you all to answer to the point and briefly to the questions posed by the public, especially because I would like to add another question to those of you that want to volunteer, because we've been identifying a lot of challenges, problems, and solutions which may not be immediate. So my question to all of you is, if we want to make a head start with improving the future of Europe, what would be for you the two most urgent but also feasible changes that might be put into effect rather quickly to kickstart the process? But Karin, can you perhaps first also relay the questions that were posed through the Q&A chat?
Okay, so we will finish with two general questions. The first one, what role for the European Union the panelists see in building an alliance of democracies as proposed by President Biden during his campaign in order to strengthen the rule of law, human rights and democracy worldwide? Would this alliance need new bodies like a G10? And I think it is also, we can also tackle this question as far as I is concerned. The second question is, could the Conference on the Future of Europe be used as a push factor for the European Union and member states to change their narratives regarding asylum and migration and regarding the respect for the rule of law by member states? And why not the EU as well?
Who would like to take the floor on this? I had push but not pull, so. Elspeth, you want to answer that, or?
I'm happy to step up on this one. Yes. On the first question, an alliance for democracy between Europe and the US. And I think here the long influence of the Trump years are very much at the foremost of everyone's minds. We have a new president in the United States. I think most of us are extremely pleased to have a president who's interested in democracy and the rule of law in a profound way. But we've had a very rough ride over the last 5 years with a president who was elected in a free election in the United States and who proceeded to act in a whole series of ways which we consider to be very problematic. And it's not as if that's the end of the previous administration in the United States. There are quite a lot of Americans who voted for that particular style of populist leader. And therefore, I think we all thought this would be impossible in the United States before the election that brought President Trump to power. Now that we've seen that it is possible, we're much more careful about how long-term we bind ourselves to the United States, which in another 5 years might elect an equally erratic leader. So yes, very much so, but I think we're all feeling a bit concerned about how enduring the resurrection of respect for rule of law is in the United States. So let's absolutely work for it, but I don't think we want to bind ourselves in some kind of international agreement, which could then be used against us if there was a Trump bis elected in the next US elections. On the question of using the Conference of Europe as a push factor to achieve more rule of law and fundamental rights in migration and asylum, absolutely, I think this is something that we absolutely need to be working on. We need very much, I think, one of the things that Inga is going to come back to us with is what can we actually do now and whatever. And I don't know whether I'm allowed to address that immediately, because I think that's certainly part of what I would say. And I think the
Yes,
first thing I would say, in this area, words matter. Language matters. And just as I started out saying, well, between a migrant and a third country national, an EU citizen exercising a free movement right, and a long-term resident third country national in the EU, how does the language transform the way we see people and the way in which they're perceived? And I would say what could be done very easily and very quickly with a bit of push from the top is for the EU institutions, starting with the Commission and the Parliament, to remove from the language of all EU documents and all speeches the push-pull theory approach to migration. Just say, we are not going to use this language any longer because it represents a profound deformation of the whole field. We did this once already. Back in 2004, there was a big discussion with the colleagues in DG Justice about using the language of a balance between freedom and security. And the commissioner was convinced that the idea of a balance, that if we have more security, we have less freedom. If we have more freedom, we have less security, was a completely inaccurate and inappropriate way to look at the relationship between freedom and security. You have no security without freedom. You have no freedom without security. These go hand in hand. They are not in a balance of give and take. And for a long time, that language went out of all of the Commission documents. It's only has come back in the last few years when things have moved on and new commissions come in. They've forgotten why that was such a pernicious and negative way of talking about freedom and security. And so we could do this. We could take push-pull out of the field of immigration because we know it's inaccurate and it's incorrect and it confirms and reinforces prejudices which are based on grounds which are not permitted in EU law. The second thing I would say is we absolutely need to demilitarize the perception of external border control. Somehow Frontex has started putting on its website these pictures of almost militarized boats of border guards dressed like military officers with guns. We have had this complete militarization of the language and the images of what border control is. And I would say after 1989, let us remember that we in the European Union spent a lot of time and money convincing our Central and Eastern European colleagues who were going to become member states to demilitarize their border guards. They had to turn them into civilian agencies, no longer military agencies, because the border is not a place at which we expect war to happen. The border guard is there to admit people into the country. And as Frontex itself has told us, when someone turns up at an external border of the European Union, the border guard has 12 seconds to make a decision, because the realities of what happens at land borders, on busy roads, at airports, etc., mean that if the border guard takes longer than 12 seconds, there's going to be a huge backlog and nobody's going to be able to get through. And we will not tolerate that. We, the people of Europe, will not tolerate that. So let us not create the imaginary of what happens at the EU external border as a place of military action. So those are my two recommendations and my answers to the question.
Thank you, Elspeth. That's very clear recommendations that can be put into effect indeed very quickly and can have a great impact. Who wants to intervene next?
I'll say
Paul.
something. I think there are moments which are for tomorrow, and that is the day-to-day politics of budget and legislation. Admittedly, in a member state more than in the union, because sometimes in the union legislation also takes a long time. And there are other moments in politics which are more about the long term and which are about common perspectives and visions. And I think we also have to grant ourselves that space. So my answer to your question is, I think it would overcharge the Conference on the Future of Europe to demand from it to think the long term, to think about what opportunities in the European Union with the UK leaving, headline, can we work on all these unanimity requirements which were so dear to the United Kingdom and transform some of them? Can we get to majority decisions in foreign policy? And I would say the key thing now on the European Future of Europe conference is that there must be engagement from civil society and parliaments and so on to make this substantial. I must say I find a certain lack of leadership on substance from the side of the executives. It is not enough to say, oh, we're just going to make a conference to bring. I mean, we have to put substantive proposals on substance on the table. And I think, there some more political engagement and pressure and thinking is necessary, because otherwise this is just going to be a talking shop, which is, dressing up as if, but not really moving anything forward. And I think it would not be good to do something like that. We should not in the European Union, also in tensions and so on, with an exercise which looks as if, but is actually not.
I fully agree with you, but I think one is not excluding the other. I think it's very important to pinpoint what can already be done now to kickstart and to put the project in motion, as it were, and then working towards the bigger and long-term goals. Otherwise, I fear indeed that we will only be talking and talking and talking about what are the problems and where we'll be heading if we do not dare to pinpoint what steps can concretely be taken already now and which are to be left for a more longer-term vision then to expand upon and to agree upon. So I wouldn't see it as a binary, either or. I think it's something that should go hand in hand. And we should be taking step by step, but in the right direction. We should know what direction we are heading in. So I'll repose my question. If there are anyone else on the panel who would see two possibilities to take immediate action so that this will already be off the table for that further reflection of where can we move further in the medium or long term.
I can give it a try.
Yes, good.
Well, I think we live in a very strange time to really organize a debate on the future of Europe, because at the same time we are under an emergency that is due to the pandemic and the ensuing economic crisis. It will also be a time in which the relationship between national governments and their national citizens will be a bit more mediated by the presence of the European Union, because of the amount of funds that has been dispersed in a number of countries. And the control over how this money is spent is, as of now, still going to fall in a sort of the typical multi-level governance relationship, where there's a center that controls the periphery. I think that a useful idea would be for the EU institutions to appoint, perhaps in universities, in member states, watchdogs. Students and young researchers should be watchdogs of their own governments in the way on how they spend funds. It's a way to decentralize the governance of the European Union. It's a way to break the deadlock that we've seen for decades, in which national governments have an inevitable temptation to Europeanize all the failures and nationalize all the successes. And it's the way in which the current multi-level governance of the EU has been built, is the way in which the Brexit narrative went, however manipulated that one was too by the social media. And that is also what we have seen, in my opinion, in realizing how little, and one of the questions was about that, how little students and citizens and also the non-citizens know about the functioning of EU institutions, what the EU stands for, and so on and so forth. So that is one thing that I would do immediately. Second thing that I would do, and it was announced, but I think it has to be done quickly and accompanied by applications, reforms, additional services, is the pan-European identity. I think that that will be an interesting way to then involve European citizens in a relatively controlled environment, in interactive exchanges, in a way that can enable, bridging of the borders within Europe that, as we've seen, are not so obsolete. Actually, the pandemic has reminded us of how easy it is to, or how tempting it is for many governments to reestablish barriers inside the single market. So these are two things that I would do immediately. I would just quickly say a couple of things about the Biden administration and the D10. I still expect the anti-Chinese sentiment to remain dominant even in the Biden administration. It may be with a different style, but I mean, China has become an obsession for the United States over the past years. It will most likely remain an obsession, because this is also a very easy message to pass on to the civil society. It's a very easy enemy to build. Now, my fear, on top of what Elspeth was saying before, which I subscribe to, who knows what happens in 4 years, no? But my fear is that the D10 would be a way to break the dialogue with China, which in my opinion is absolutely dangerous. We see the problem of the potential splinter net that has been discussed in the digital sphere. I mean, the fact that even collaboration between scientists, but also the protocols that make, to some extent, the internet completely integrated at the global level, potentially a risk today. So breaking that dialogue, in my opinion, and creating a coalition of would-be like-minded countries, which are not entirely like-minded, in my opinion, would be a way to increase the instability at the global level. And then a tiny footnote for the question that I receive on code ethical conduct on artificial intelligence. There are hundreds of such conducts. They are not enforceable. This means that they are not enforced. They are not trustworthy. So I think we've seen after several years that the time is ripe to do what the European Commission is trying to do. Whether everything will be done properly from day one, I'm not sure, but someone has to try, and the European Commission is showing a lot of courage in trying to regulate AI in a rather assertive and bold way. And this is perhaps the last thing that I think is a lesson to be learned also for the future of Europe. Europe has to continue remaining assertive for the values it stands for, perhaps explain them a bit more, explain how they evolve over time, because the famous EU values are very nebulous. to many of the Europeans, and behave coherently. And again, the migration discussion is evident, self-evident in that respect. Behave coherently in pursuing those values in all aspects of EU policy, from the better regulation part. So what determines whether a legislation is preferable, is desirable or not. So really the daily job of the institutions, to the different policy domains in which the EU projects itself, sometimes in a very diverse, in a very heterogeneous way, showing a lack of coherence, which then translates into a lack of, if you wish, actorness at the global level.
Thank you very much. On this note, I would like to end the session and thank all our presenters, speakers, discussants, and also all those in the public that have asked questions. I hope you've received some answers, but of course we have further sessions today and also tomorrow. Tomorrow morning, we'll also talk about the external relations of the European Union and the European Union in the global setting. So China and the US will definitely come up there again. For now, I would like to invite you all to stretch your legs and take a break. My students have taught me that among the fundamental rights, there is the right to disconnect from time to time from the screen. So this is such a time. It's time to take a break, but I hope you'll all be back sharply at, I think it's 4 o'clock, we start again. And I look at the calendar, yes, 4 o'clock. So at 4 o'clock sharp, I give the chair to Professor Costa from the Politics Department. Once again, a big thanks to all our speakers.